Hi, hello guys. So yesterday we were discussing about due process of law. Particularly, we discussed due process and its historical background in American political setup. Today we are going to discuss its parallel concept, parallel to due process of law, and a very prominent concept which is frequently used in different political systems, and it is more so important because it is used in our country, India, and it is also used in Japanese political system, in British political system. So today we are going to discuss about a concept which is known as procedure established by law. So in this concept of procedure established by law, the fundamental difference between due process and procedure established by law is of the fact that that primarily when we talk about due process of law, yesterday we discussed, due process puts the citizens first, and due process says that state is created by citizens, and rights and liberties are reserved are reserved of the citizens, and state does not give rights to citizens, state does not give liberties to citizens, so state has no right to encroach upon them. Quite contrary to that, in the concept of procedure established by law, it is the state which is the primary institution and not the citizens. So when we put state first and citizens later, by default it means that it is the state which gives laws to citizens, it is the state which gives rights to citizens, it is the state which gives liberties to citizens. So state becomes the right giver, state becomes the protector of the liberties of the citizens. So since state is the authority which gives rights, it has more authority to amend in those rights or to take back those rights as per the convenience. So before I delve into the constitutional history vis-a-vis Indian political system of procedure established by law, we must first take a look of what procedure established by law basically mean, what at the basic level, at the most fundamental level, what procedure established by law means. First of all, the term itself, the term procedure established by law that we are discussing today, it tells us about a political system in which state is primary, state gives rights to its citizens to protect, and state ensures that citizens live a life in which they can develop their inherent potential. So in a country like India, when Indian constitution was being written, the founding fathers or the constitutional framers of India discussed this vigorously, and they debated that what sort of system should be adopted in Indian constitution. Dr. Ambedkar was in favor of adopting due process clause, as was evident that this due process clause has helped significantly in safeguarding the rights and liberties of the American citizens. So Dr. Ambedkar was in favor of adopting this due process clause in Indian constitution as well. But the things were not as simple as they seem to be. What happened was, when this concept was being discussed, B.N. Rao, who was constitutional advisor to Constituent Assembly of India, he went to America and he discussed this with an American Supreme Court Chief Justice, and then came the conclusion that this due process clause would be a hindrance in developing India, because mind you that the Constitution of India is not only a legal or political document, it is also a document which is to safeguard and promote the social revolution that Indian freedom fighters aspired for. So Indian Constitution is not only a political legal document, it is also a custodian of the social revolution that was to take place after India achieved its independence. So had India adopted due process, that agenda of changing the society, that agenda of redistributing wealth, that agenda of freedom fighters of making a new India would not have been completed, because at every step this due process clause would have forced judiciary to intervene in government's affairs, and there would have been a clear tug of war between different institutions of governance, between different institutions of government. So if India had adopted for due process clause, suppose if legislature makes a law for redistribution of land redistribution, then by default judiciary would have had to intervene and protect the right to property, and in that sense there would have been no recourse to this inevitable conflict, and the country would have come to a standstill. So in order to avoid these events, these kind of catastrophes, I would say, the constitutional framers of India, what they did was they opted for procedure established by law, so that there could be a definiteness in authority, so that there is no debate as of who is to govern, or which institution is to lead India. So what they did was they opted for the theory of procedure established by law, and this theory, procedure established by law, is more suitable to Indian situation, because we got our independence in a very tragic situation, I would say. At that time, India was divided in the name of religion, and even the Hindu society of India was highly divided and very ridden of some social evils. So the Constitution of India was to be a custodian of a social revolution that was to be unfolded after India got its independence. So what this procedure established by law does, that is, this concept creates an environment in which the legislature of the country holds supreme authority, and the responsibility of the judiciary is limited to the extent of checking whether the executive of the country is working according to the procedures established by the legislature. And the second responsibility of the judiciary is to check whether the legislature of the country is working according to the framework which has been provided in the fundamental law of the land, which is the Constitution itself. So when it comes to the theory of procedure established by law, first and foremost we need to understand that any country which opts for procedure established by law by default limits the ambit of its judiciary, and second, it enhances the scope and powers of the legislature of that country. Third thing which we need to understand in this concept is that procedure established by law tells the judiciary of the concerned country that that judiciary is only to check whether the said laws made by legislature are made through right processes, and those processes are already given in the fundamental law of the land, which is Constitution. So has legislature made the law according to the procedures laid down in the Constitution? Has it followed all the relevant criteria as given in the Constitution itself? So there is no, in this concept, there is no such thing as natural laws. There is no such thing as natural rights of citizens. So judiciary cannot question the intent of the legislature. When it comes to procedure established by law, the judiciary, although powerful, but can only check whether the legislative act follows the procedures and parameters that are given in the Constitution. So in essence, we can say when we are talking about procedure established by law, judiciary can only check the constitutionality of a legislative act. Okay, the term constitutionality of a legislative act is very important here, because this is the essence of procedure established by law when it comes to legislative acts. And for executive acts, I'll explain it in a minute. What we are talking about, when a country opts for procedure established by law, it limits the authority of the judiciary, and it specifically tells that legislature is to lead the country, and it will be the job of the judiciary only to check whether the legislative acts are under the ambit of the constitutional procedural norms, and it can only check whether the said law is according to the procedures of the constitution or not. It cannot question the intent of the legislative act. It cannot question whether the said act is in favor of citizens or not. If it is in accordance with the constitution, then this law cannot be declared null and void on the grounds of natural law or natural rights or theories of natural justice, etc., etc. So what we need to understand is that unlike due process of law, in which a legislative act can be questioned on the grounds of being in contrivance with the natural law, in procedure established by law, a legislative act or a law passed by legislature cannot be questioned on the grounds of being in contrivance with natural rights or natural laws or natural justice. Okay, judiciary can only check the constitutionality of a legislative act. It cannot question the intent of a legislative act. Second, when it comes to executive acts, in a country which opts for procedure established by law like India, Japan or Britain, executive actions can be judged on two grounds. First, judiciary can check whether the executive has acted according to the procedures already laid down by the legislature, and second, it can check whether the executive is acting inside the framework which has been provided to the citizens by the fundamental law of the land. So judiciary can check whether the rights and liberties which are guaranteed to the citizens according to the fundamental law of the land, that is constitution. So executive cannot violate the framework provided by constitution. So first, and second, the executive while working cannot under no circumstances violate the procedures already laid down by the legislature. So this theory of procedure established by law is mainly about the relationship between different organs of the government and citizens living in that state, and how judiciary is to play its role while maintaining this relationship. So if any country opts for procedure established by law, that country's judiciary can check the executive power, can check the constitutionality of the acts of the legislative organ, but it cannot check legislative authority in a substantive manner, like we saw in the case of due process of law. Now, for a country which opts for, when it comes to India particularly, not for any other country, when it comes to India in particular, the fundamental difference between India and Britain, although both countries opted for procedure established by law, the fundamental difference is that India is a constitutional republic. India firmly believes in its constitution, and there is no such thing as a constitution in Britain. Britain follows a common law tradition, and there is a parliamentary supremacy in Britain. But in India, although India opted for procedure established by law, but there is no such thing as supremacy of the parliament. India, although opted for procedure established by law in theory, and even written it in the constitution itself, but still India and the political system in India and the political traditions of India firmly believe in the supremacy of the constitution and not in the supremacy of any other government's institution. So there no institution is supreme in India. It is the constitution which is supreme, which is in India. So although India opted for procedure established by law, but we all know that in 1973 the famous Keshwanand Bharti case gave the doctrine of basic structure of the constitution, and even the parliament, by using its amending power, cannot change the basic structure of the constitution. although the rights are given by the constitution, but those rights are protected in the same manner as are done through the process of due process. So the constitution in India becomes supreme, and through that constitution the theory of the theory of procedure established by law is perpetuated. Okay, thank you.